voluntariness of consent must be analyzed based on the totality of circumstances. And
That's what Sandoval says, my
Now,
friend.
hold on, let him finish. Let him finish.
and no statement, whether it refers to the consequences of refusing a blood test, the consequences of passing or failing a blood test, or otherwise, should be analyzed in isolation because its impact can only be understood when surrounding circumstances are accounted for. In other words, allowing any statement by itself to control a voluntariness analysis contradicts the basic rule that voluntariness must be determined based on case-specific consideration.
Sure, of course.
And then they explicitly say, therefore, because of its flawed reasoning and the flawed case law that results from it, we overrule Erdman, which is what that Serrano case relies upon, is Erdman.
So Judge, so Erdman, just, by the way, didn't overrule Erdman in its entirety. So what they're saying is the construct. So let's think about what Erdman was. In Erdman, the officer read a statutory warning, okay, that said that if the person didn't give a breath test, that they were going to get blood. That's not coercive. That was reading the statute. So if you read the case that I cited, Serrano, and then there's Navarro after that. Law.
So, and I want to give you time to look at everything, right? But I mean, this is like right on point with this.
100%.
Right on point, right? So if Erdman is right on point with this, then okay. But if it's not right on point with this, then it's...
And Judge, then there's Sandoval as well. One of your sister courts just 2 days ago also ruled in an exact situation like this, when an officer gave the improper admonishments that, hey, you know, if you give a breath test, I'm going to take you home.
Okay, so I think that we're getting way ahead of each other. So let's, first off, we're not on the record, are we? Yeah, we need to get there. So, yeah, we're getting way ahead of ourselves. So, all right, Ramona, you ready? Guys, we're going on the record. If you want to talk, go outside, please.
Consider waiving hers in the trial on that.
Yeah,
Yeah.
yeah. As long you confirm. Okay, I trust you. All right. We are on the record in clause number 250542.
All right, folks, big case here, State of Texas versus Stephen Garcia. This isn't just another DWI trial. The defense is challenging the very breath test itself. Quick question for you. Do you think a test should be thrown out if the officer promises something he legally can't deliver? Let me know in the comments.
8, State of Texas versus Stephen Garcia. Today is February 11th, 2025. It's approximately 9:49 in the morning, a.m. Guys, I'd like you to please announce yourselves for purposes of the record. State first.
Jenna Davila for the state of Texas. Mackenzie Watson for the state of Texas.
Jim Butler for Stephen Garcia.
Okay. So I think that we were getting ahead of ourselves here. We started without even going on the record. So today is day for trial. Both parties have announced ready?
Yes,
This should.
Okay.
we're ready.
So what we have here is just kind of a brief introduction and where defense has challenged the breath test in this case and its admissibility thereof. You guys have reviewed everything outside, correct?
Yeah, Judge, so just for the record, the state and the defense sat down in the back room and we kind of went through some of the motions. We went through the motion that I just filed. And then we also began going through the motions in limine. So, and then of course, we brought this motion to keep the breath test out, basically because the officer gave language that was outside statutory language that they are supposed to give when they're offering somebody a breath test. And we're alleging that he basically tells my client, hey, look, if you blow, and if you blow under the legal limit, I'm going to put you in the car and take you home. And the evidence will show that my client relied upon that. In fact, at one point, when the officer is cuffing him and stuffing him, he's like, well, wait a minute, you said I was going to get to give a breath test, because he believed that he was under the limit, wasn't going to register, over 0.08, and was relying on the fact that if he gave that test, all of this ended and the officer would cut him loose and take him home. And then, of course, after that, And after the officer said, no, we got to go downtown because our machine's downtown, he again repeated that and said, look, if you blow under, we're going to get in the car and I'm going to take you home. And again, repeated that. And my client relied upon that and thought that that would happen. Of course, that's not what's going to happen. And Judge, and based on your experience, it's also possible that he could go down there and blow under the legal limit and the DA could still accept charges for DWI. So that was impermissible language that should not have been given in this case.
Response?
And one other thing,
And if
Judge.
you're not ready yet, it's okay, because I know that we're
Okay,
kind
I was
of,
just giving her the opportunity of what she wants to do. We did review the facts on the motion. We agree that the facts stated were as reflected on defense's motion. However, we do disagree with the case law given to support the fact that just because of the statements given by the officer, the breath test should be excluded. The underlying case law has negative treatment by the Texas Criminal Court of Appeals, and there is other cases within the same jurisdiction that have different treatment. However, we have come to the agreement that because what the case given by defense, once it goes upon appeal, it is only reviewed for abuse of discretion, and the case that overruled or gave negative treatment to Erdman says the same thing. Basically, it is the totality of the circumstances, and if you're able to relate a certain link between what was specifically said to the officer and what the defendant believed to be true, and if that gave him a specific idea of what was going to happen or moved him towards the direction of the breath test versus the blood test. So I think we're both in agreement that the only way to resolve it is by you reviewing what was exactly said by the officer on the timestamp was given and using the court's discretion to come to the conclusion.
let me ask you this. Have you had a chance to see whether Serrano, the case that he provided, I mean, it's right on point. Have you
It has not been
seen?
overruled, just so you know. And I think just to give you a little more information. So I agreed with that treatment of Erdman. I thought that it was not that great of a case because in Erdman, look, you had a officer that was doing nothing more than reading the statutory language. I mean, he wasn't even saying like, hey, go down there and give a sample. And if you are under, I'm going to take you home, which is like dangling candy in front of a baby, and that's the kind of thing that the law wants to prevent. The law says, here's the statute that you read. Navarro, which is another case that's cited among the cases that we're talking about.
I understand. Is there something that negates Serrano? Is there a case that says, hey, saying something like this is okay?
It would just be Finan, which is the Texas Criminal Appeals case that just states that it was not a breach of discretion to keep it out and that it would have to be a totality of the circumstances.
Okay.
And we 100% agree with that, and we know that. And so, Judge, the other thing that I wanted to say without going into Erdman is the Navarro case talks about, it's very good, and it talks about what the statutory language should be and why it is there and what it informs the person. If you give a test and if it's over the limit, here are the consequences of that. If you refuse the test, here are the consequences with your driver's license. And then, if you refuse, we can get a warrant to get your blood. That's all they're supposed to give them. And then they sit back and then the person either agrees or they don't agree. You can't sit there and then start enticing the person by telling them things to get them to change their mind. And clearly you're going to see that on the video. This officer says these extrajudicial statements. Hey, if we go down there, if you blow over or under, pardon me, we're going to get in the car and I'm going to take you home. Now, if you blow over, you're going to be arrested. But if you ask for a blood test, then you're also going to go to jail. And, it could be a week or however long before that blood comes back. So he's thinking, man, I better go down there and give a breath because I'm going to go home. And you just can't be saying stuff like that.
we have a panel here ready to go. So I don't want to keep them waiting. You know, they've already been waiting for, 30 minutes. So how do you guys want to proceed?
Interesting twist here. The judge doesn't want to waste the jury's time, but the breath test challenge could change how the whole trial is presented. Timing is everything in court. What would you do? Push forward fast, or pause to sort out the evidence battle?
Judge, if it's okay with you, I'm
Are
happy.
you ready to argue the merits of this? Because what I was going to suggest is that we go ahead, pick the jury, and then we can just start and finish argument with this
Well,
right after.
the only thing that
I don't
I,
want to keep them waiting.
no, I understand that. The only thing is that kind of does change the voir dire a bit, doesn't it?
If you want to exclude the breath test part of your voir dire, then I guess it can be talked about. It's not totally excluded, even if it gets excluded, because we can't force them into specific facts that
No,
there
of
is no
course,
breath
of
test.
course.
So I think we.
I guess we're ready to roll. But, and then we can.
I just want to keep them waiting. Let's get it started, and then right after we get done with the paneling, then we can,
Sure.
and then that'll give you more time to look to see if there's something else that you want to look at as far as case law or whatnot.
And Judge, we'll print a copy for the court of the two outstanding case law that we have.
For sure. Okay. Any lawyers want to approach real quick before bringing the jury in?
Yeah.
Are you, you want to do your plea?
Yes, Judge.
Okay. Yeah, let's do it. All right, guys, if you're in the middle, we're going to ask you to please move over to the side because we're going to have a panel coming in and they're going to sit in the middle, please. So if you just don't mind, if you don't mind, please move it to the side.
I'm in the sign.
Yes, he's coming.
Huh?
I was hoping you could finish briefly.
Yes, no, we'll get it done today. Hi, talk to me. Yes.
On Victor Navarro. This is an assault of a family member. His mom is here, who is the complaining witness as well. There's a protective order. I am requesting that the court lift the protective order. She is the only person to take care of him. I spoke with her this morning.
Spoke about a couple days ago.
No, this is new. This one is new for me.
It's on document.
It is on docket today.
Is he in jail?
He is in custody, so I'm asking for two things today. One, a PR bond. He does not have any other violent criminal history. Also, no other cases pending. I'm not sure.
Let's read this. Shh, everybody keep it down, please. Hey,
Yes, Mom.
Alex, I'm going to read this. You ready? This is on Navarro. Okay, let me read this to you. This is why the magistrate did not give him a law, because I don't know.
Right, okay.
No adult criminal history, Harris County. No charges since 1999. This case, defendant is complaining witness's son. Complaining witness reports defendant got angry when he was asked to help move a shelf. Then later in the day, pushed complaining witness down to the floor and began punching her repeatedly, causing pain and scratches to her face. Defendant has been diagnosed with mental health issues. Complaining witness wants to press charges because he needs to learn his lesson and could possibly kill her one day if she does not take action. Her AFC defendant is not employed. Spanish speaker on AFC, English in court. Defendant declined PDO and appointment of counsel, but per PDO, he is 1622 consented to prior to docket allowed PDO to represent a PC. I need to talk to him. So, yeah. Yeah, let's bring him out.
Okay.
We'll talk. All right, come on. Bless, you ready?
Yes, Your Honor.
Okay, come on.
Yes.
You are Alberto Lopez.
Yeah.
Mr. Lopez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You have you're charged with driving while intoxicated, second offense. You are facing up to a year in jail and or a $4,000 fine. Is it being reduced to a first? It looks like it's being reduced to a first. What you must understand that this is still two. So if you ever pick up another DWI, you will be facing a felony charge of a third-degree felony, a minimum of 2 years in prison, a maximum of 10 years in prison. If I were you, I would never get into a car and drive if you have even had a sip of alcohol because you were playing, you're taking a humongous risk. Do you understand?
Yes.
You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you plead guilty, there is no changing this. It will go on your record. It'll be there forever. How do you plead to the offense? Guilty or not guilty?
Guilty.
I'm going to find you guilty. I will send it you to the agreement. I'm going to suspend your ability to drive for 1 year. Do not drive until you get a license. And good luck to you, sir.
Thank you, Judge. And Your Honor, I was appointed to this case. I don't believe my client's financial status has changed since he's been in custody. But we asked the court to waive the DPS fee. Thank you, Judge.
I'm gonna- Good morning, Mr. Navarro. Do you speak English, sir? If you're going to play games, it's just not going to go well, man. You know, really.
Respectful, please.
Your lawyer's asking me to give you a PR bond, but if I know now that you're going to give me issues, I'm just not going to do it, you know? My soul, the only thing I want to do is protect the public. Do you understand? So your lawyer's asking me to, give you a PR bond, but what I need to know is if we let you out, is there going to be a problem with mom?
Judge, I'm also going to do jail release instructions. So if we could do a jail release order so that he can go to the Harris Center. Mom is right here. Miss Francisco? The main concern, Judge, he needs to get on his medication. So I spoke with Mom. If we can do a PR bond, I can do a jail release order for him to go to the Harris Center.
Blas is still here. Do you speak English, ma'am?
Yes.
Oh, wonderful. Okay. Are you okay if he goes back to your house?
I want, if you just wanted to get him like a getaway, that's what I want.
So what,
I wish I could just find a place where they could.
This is heartbreaking. You can feel the mom's conflict. She's the victim, but also the only one who can care for her son. This raises a tough question. Should courts balance justice with compassion when mental health and family are at stake? What do you think, protective order or second chance?
Days a month to make sure he is on medications and stuff like that.
well, I can make it a condition of his bond that he's supposed to take his medication. And if he doesn't, then,
That's what makes him start acting out because I can't force it anything.
well, I am now making it a condition of your bond that, Mr. Navarro, if you want to be out on a PR bond, you have to take your medication. If you don't, then no more PR bond. Do you understand? I'm not asking for much.
He's not he doesn't even know how to talk to people. His mind is like sometimes not there, you know what I mean? He understands certain things, but I just have a problem with him. He takes it out on me, not no one else, you know what I'm saying? And I don't want to get him spraying on him because he's gonna be on the street homeless, and I can't let my son live in the street.
I got it. I understand. And I'm okay with it. Mr. Navarro, do you want me to let you out?
Out my home house, whatever.
You have to understand though, I want you to take the medication. Do you understand? If you do not, Mom is going to call us, let us know, and then you're going to be right back here with us. So I want you to understand the only thing I'm asking you to do is take your medicine and be nice to mom. It's not hard. When you take the medication, good things happen. Can you do that for me?
Yeah.
You promise? I'm serious.
Okay.
So mom, I'm going to give you, we're going to give her your phone number. So if you have any problems, call her, let her know. She'll talk to me and we'll take care of business for you.
Tell him that if the cops show up, he's not gonna get out. He's gonna stay here.
Come on, everybody.
You say that, Junior, because we're here in front of the judge.
Okay.
But you have to take life serious, Junior.
Mm-hmm.
That hurts if you like this.
We don't want to keep you.
Okay, that sounds good to me, but still, I can't.
Next time you're getting out,
Okay, I know.
you better.
Okay, Mr. Navarro, make me proud, huh? Just keep taking the medication. Good things happen, all right? Okay,
Thank you,
yeah,
Judge.
I'll grant it for you.
Thank you.
Okay, ma'am, any problems, just let us know. We're here to help you out, okay? Really.
So they can't keep him in the hospital like for a
What we'll do is
month.
we can, we can do jail release where we'll take him to the, no.
I will go to my holistic department and we will find resources for that. But I did explain to her that the Harris Center would just take him from jail, do the evaluation. They can't keep him there.
Problem is that at the Harris Center, we can't hold him. We can't force him to stay. If he wants to leave, he can leave. We just can't.
I know.
That's why we will be in contact.
But they have resources at the defender's office to help you out. So whatever you guys need. And then just stay in touch with us if you,
I'm trying to get out of the journey, but I don't
We will
like
help
more.
you. We can help you do that.
we'll help. Okay.
Thank you, Judge.
Good luck, ma'am.
That was for Navarro. Any bond conditions for?
No weapons and take medication.
Yes, Judge.
The state wants to approach on an extradition case. I oppose.
We're asking to approach on Nelson Moore, call number 255-0421.
255.
0421.
Okay.
Your Honor, he is wanted out of Multnomah County, Oregon on 5 counts of sexual abuse. He's got a $1,250,000 bond. The demanding jurisdiction has requested a 3-day reset due to staffing issues.
Have you had a reset before?
I'm sorry?
Have you had one before?
A reset? No, Your Honor.
They haven't. I have to object.
Okay. I'll grant it for you, but that's it.
Thank you, Judge.
Okay.
Thanks,
sir. Okay, are you ready? All right, bring it in. Rock and roll.